What's this about?
I have a new charge for you.
New charge my ass.
Mr. Japkus, do you understand those rights?
I'm not stupid, yep.
Do you understand those charges?
I'm not stupid, yep. This won't go nowhere. You can appoint one. I don't want hardtail. You can just set a bond because I'm already in jail and I ain't going nowhere. I don't even give a fuck. So you can drop that.
I refuse to participate.
I'm not stupid. I can stand trial.
This is Mr. Japkus. The key takeaway from his arraignment is that
I'm not stupid, yep.
he echoed the same at his competency hearing a few days later. I've watched both, and I can confidently say he's not stupid, just deranged, and argumentative, and defiant, and uncooperative, and resistive, and generally living in his own world where he thinks he's above everyone else. But he didn't just convince me.
I'm not stupid. I can stand trial.
He also convinced the judge. The trial ought to be good. Let's roll it.
Mr. Japkus, are you able to see and hear the court?
Yeah.
I know this arraignment came rather quickly. You have not had the opportunity to meet with a public defender. Is that my understanding?
No.
Would you
Yeah.
like that opportunity?
What's this about?
Well, I have a new charge for you. Would you like the opportunity to meet with a public defender?
Yeah.
All right. I will put you in a breakout room.
New charge my ass. I ain't did nothing. I'm in jail.
Mr. Japkus, you have certain rights, and I'm going to go through those rights with you. If you require accommodations to use the court because of designed by the court to require those witnesses to come to court, to see, hear, and question all witnesses against you at trial, to be a witness for yourself or to remain silent. If you choose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. You also have the right to be presumed innocent victim in other similar relationships. Mr. Japkus, do you understand those rights as I've read them to you?
I'm not stupid, yep.
I have a complaint that alleges that on or about May 27th, 2025, in the city of Cadillac of Wexford County, it is alleged in count number 1 that you did make an assault or assault and battery upon Corrections Officer Pacoda. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500, and consecutive sentencing may be imposed if the assault happened in a place of confinement. Do you understand those charges and the potential penalties?
I'm not stupid, yeah.
You do have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one, one would be appointed to represent you, but you may be required to repay a portion of that expense. Today, do you plan to hire your attorney, request the appointment of an attorney, or represent yourself?
This won't go nowhere. You can appoint one.
All right, the court will make a referral to the public defender's office for the appointment of an attorney. Enter not guilty.
Cartel.
Well, I have no control over that.
Well, I'm already firing him from circuit, so I don't want hardtail.
Okay, well, that's up to the appointing agency, and the court is not the appointing agency. That's up to the public defender's office.
Keep it going, man. I'm already in jail. I don't care. That's never going to stand. Keep it going. What you got to say?
The court will set the matter for a pretrial conference. That's where your attorney and a prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, do I need to go through Mr. Japkus' criminal history with either?
No, you don't. You can just set a bond because I'm already in jail and I ain't going nowhere. I don't even give a fuck. How about that?
And it's my understanding that the defendant currently is pending charges in the circuit court, and on Friday there was a competency hearing in which he was determined competent, but I did see the register of actions where there's a request to remove his current attorney. Any comment regarding bonds in the defender's office?
Yes, just brief, Your Honor. And while I respect that Mr. Japkus is obviously frustrated about the situation, I would ask that some monetary bond be put in for this case. Some monetary bond at all, just in case he does manage to get to a situation where he could post bond. I know he doesn't claims to not care, but he might care at one point. So,
thank you, Ms. Lawrence.
Thank you, Your Honor. This was an assault and battery against a corrections officer. The defendant is alleged to have thrown a full cup of water at him. I do know he's sitting on bond in circuit court. That people would also ask for a monetary bond. Thank you.
The court believes it'd be appropriate to set a bond in this case so the defendant receives credit for any time that he's sitting. Otherwise, if I were to issue a personal recognizance bond, he would not receive credit. I'm going to set bond at $100 cash or surety. If the defendant is to appear as ordered, keep his contact information current, not leave the state without permission, and not to act any threatening, intimidating, or harassing behavior. Thank you, jail.
Now that that's done, we didn't do no advice or rights for him, so you can drop that.
We are on the record now for people of the state of Michigan versus Nathaniel Carl Japkus. This is file number 25-14053FH. Appearances first from counsel.
Joanne Carey for the people.
Robert Hartel for Mr. Japkus, who joined us by Zoom from the Wexford County Jail, Your Honor.
Mr. Japkus appears again via Zoom. Sir, are you able to see and hear us this afternoon?
Yeah.
Thank you very much. We are here today for a hearing that is required by statute after the report from the Department of Health and Human Services Center for Forensic Psychiatry. This court ordered that the defendant was to be evaluated for his competency to stand trial. According to that report, which was received in our office on July 28th of this year, and it was dated itself July 22nd, it is found that Mr. Japkus was or is competent to stand trial. However, the court is quite concerned by it. There should really be an asterisk to it because there was concerns because Mr. Japkus in fact refused to participate and was, I think, he wasn't taken to the center, but he was at the jail and refused to participate, which this court treats as the same thing as not making himself available. Mr. Harris, I'm sorry, I did speak earlier in chambers with counsel. Mr. Hartel, do you have any input at this time or anything else to offer? I mean, the question is do we think he's actually not competent or incompetent to stand trial, or that he still needs to be evaluated?
Your Honor, I do believe he still needs to be evaluated.
I understand from speaking with counsel for both parties that there have been allegedly, and plus it's also referenced in the report from the Center for Forensic Psychiatry, issues with the defendant's compliance and with the conditions of confinement and the rules at the Wexford County Jail, and it's become quite difficult for those trying to keep him in custody. So,
I can speak when I get a chance, please.
yes, sir, one moment.
Yeah.
All right, Mr. Japkus, my concern today is only whether you are competent to stand trial. Now, competent to stand trial means that you understand what you're charged with, what the maximum punishments are, what your rights are, and to be able to assist in your defense. Which means talk to your attorney, give them your input, make suggestions on witnesses to call or questions to ask. And that's all I'm asking for. That's the only information that I need today is, are you competent? Do you understand what you're charged with? Now, you said that you wanted to say something. Yes, sir. Right now is your time.
Yeah, I want to say something because I don't appreciate my client attorney privileges being messed with. Yeah, I stand trial. I've never had an issue. I'm not stupid. I don't appreciate, if you read the transcripts, they've lied a few different times in the transcripts, and that's just, they should be looked at. And I don't appreciate I really don't like him as an attorney. He's came to slot a couple of times to speak to me. I don't appreciate that. It's in front of people. That whole thing She had led the witness a few different times, and then transcripts, preliminary exam on the first in-house court date. There's a lot to it in the transcripts that I'm just not getting. And I asked him about it if he looked at it, and I'm like, man, are you serious? I mean, didn't make a positive ID. There's a lot of them transcripts that just don't make sense. And I was sitting in a public park minding my own business, so that's why I'm so mad about it. I was out 2 days not bothering anybody, and it's not right. But as far as standing trial, I'm not stupid. I can stand trial.
Okay, you said you were out for 2 days. Could you tell me what you mean by that?
2 days I was out of jail from when you sentenced me last time.
Oh, okay.
And I was sitting in the park minding my business. I don't know if you've seen the video or if you have read the transcripts or anything along them lines, but if you do, you'll see exactly what I'm saying to you, that, you know, they show calling me for fingerprints when I'm already in the jail. So that didn't make sense to begin with. Then, like I said, you violated my attorney-client privileges by coming to the slot in front of other inmates, which I don't appreciate at all. That you should have never did. And that Hartel did that 3 times. And that's why I was so mad. And I don't usually disrespect judges. I've never had an issue. I've been to many courthouses. And yeah, that's not.
All right, well, hold on one moment. Can you tell me what offenses you are currently charged with in this file?
Yeah, disturbing the peace and assault of RNO is what I have on the felony complaint. And then with one witness, but they put 2 on the stand and they put 3 witnesses on to bind it up to you, but it says RNO with you. And then they switched it up in their testimony, disorderly conduct. So they switched up so many different times in the court with her.
Okay.
Then they said I was engaging officers, which I never was actually engaging the officers, if you've even seen in the video. A lot of that crap they got going on right there is not right. So yeah, I'm upset. You're right. I'm sorry, go ahead.
All right, sir, thank you. So I've got a handful of questions for you, and so far you've already answered the first one. You are able to recall what the 2 charges are. Count 1 is the RNO, in other words, the assault, resist, or obstruct a police officer. And then the count 2 is disturbing the peace. Now, do you know what the maximum punishments are for those 2 offenses?
2 years is on one and 90 days is on another. 93 days, 1 or 2.
Yep, and there's also what's called a 4th habitual felony offender enhancement. And that has, within the court's discretion, if you were convicted at a trial, that would allow the court to increase the potential punishment for the RNO from up to 2 years to up to 15 years.
No,
Are
I'm
you aware? Okay, thank
I'm
you.
aware.
And all right, so far I want to be able to get this case moving. And so far you understand what you're charged with, and you understand what the maximum punishments are.
So
Now,
I'm
the next-
41. Yes, I do.
I know, but I'm going to ask these questions, and it might get us to where we need to go. So now at a trial, again, I'm not trying to insult you, but I have to ask these questions. What is done at a trial? What's the job of the prosecutor at the trial?
To prove that I was guilty,
All right. And what is the job of your defense attorney, sir?
to prove that I'm not guilty.
What is the job of a jury?
To look at the evidence, read the testimony, listen to testimonies.
All right. And the other thing here is I just need to make sure that you are able to speak with Mr. Hartel and testify, make those decisions about do you testify. So do you understand that you have the right to testify at a trial?
Yep.
Now, you also have another right to remain silent and not have that silence used against you. Do you understand that?
Yep.
Right? You also have the right to have the court order witnesses on your behalf.
Yep. I understand.
All right, one moment, let me take just a quick look here. This case involves an date on or about March 18th of 2025. I know we had to take it off the court's docket due to these competency evaluation questions. Now, we also had a request for a criminal responsibility evaluation, and as I understand it, that could not be done because the center said that he denied because he declined to fully cooperate. I'm going to ask Mr. Japkus another question. Mr. Japkus, I don't want you to tell me what you remember. I want you to tell me, do you remember this alleged event back in March down in the city park?
Yep. Yes, I do.
All right. And do you remember who was there with you? I mean, the officers, can we,
Yep.
I don't want you to tell me what you did, but just, do you remember that there were police officers?
Yep. Nick Noel, Ryman, and Carlson.
All right. Okay, well, we came in today, or I did, with one approach that I thought we might be going to, but I don't know, I'm going a different way. Ms. Carey, do you have anything further to add or present at this time?
I don't.
How about you, Mr. Hartel?
Your Honor, I would note that I do believe Mr. Japkus does appear to be doing better in the last few times I spoke with him. Upon review, without going into too much detail of the body cams and other discovery, I do still have concerns for criminal responsibility, but that's all I have to say. Thank you.
All right. Well, the choice to pursue criminal responsibility, which is also known as the insanity defense, is held up, is determined by the defense. And if we still wish to have him evaluated, I can order again to have him evaluated for that. Let me take a quick look here at the letter.
Yeah, he offered me a 1-year misdemeanor. That's the funny part.
Hold on, hold on. Okay. All right. So I can refer him back to the center for another, well, not another evaluation, but I can refer him to the center for that evaluation. Mr. Japkus, a defendant has the right to assert a variety of defenses, and one of them may be whether or not a defendant appreciates the wrongfulness of actions due to any mental disability or disease or defect is what the law says. And Mr. Hartel has asked for you to be evaluated for criminal responsibility. Do you know what that means?
I do. Like I said, I have been, I don't need him to do anything. I can stand trial. I don't need him. Actually, I'd like to have somebody different. Like I said, he's violated my attorney-client privileges a couple times. I don't appreciate it. So,
all right.
But yeah, I understand.
All right. All right. So let me turn this into yet another question. Mr. Japkus appears to be telling the court that he feels that there's been a breakdown of the attorney-client privilege between he and Mr. Hartel, and he's requesting appointment of another attorney. Is that correct, Mr. Japkus?
Yep.
All right, thank you. Mr. Hartel, do you have any input to add there?
Cautious to say anything that was communicated between myself and,
I don't want you to do that.
okay,
So-
ironically for the same reason.
Yeah, that's okay.
What I will say, Your Honor, is although I still have many concerns for many reasons with this individual client, I am definitely willing to pass along his noted concerns of my representation to the defender's office.
All right. So, Mr. Japkus, what I am concerned with is not only your rights and your rights specifically to due process and a trial, it's also your right to have effective representation. And I can have another attorney appointed for you. But again, my other concern here is your mental health and your ability to get through to a trial. I note that sometimes there has been some, well, at least it's been reported, that there has been some difficulties in communicating with you. If that continues, then I have to keep going back and say, well, maybe I need to send them to the Center for Forensic Psychiatry. Have them committed there, so before I can even get to a trial. But
Sir,
I can tell. Okay, hold on. I'm almost there.
I've never
So again,
that.
I got it, hold on. And while I have heard things that give me concern, and I've seen a little bit of it, I think, before on Zoom. Right now, what I'm seeing is a person who is answering the questions correctly, who understands what he's charged with, what the maximum punishments are, who understands what happens at a trial, what the roles of the jury is, what the roles of the attorneys are, what his rights are at a trial. So I want to get that trial done. So I guess what I'm trying to say is, to whatever credibility there is or isn't as to what your conduct might be, I need it to stay positive, like it is right this moment. If it does, then I can get this case to trial. If it doesn't, and there's disruptions and you can't communicate with the lawyer, then that makes the lawyer compelled to try to do the best thing for you, which might be a competency evaluation and criminal responsibility defense. So right now, what I'm seeing from you is somebody who is calm and knows all the answers. So I want to assign a new attorney for you, which I'm going to, well, I don't do the assignment, but I'll refer it for the appointment of an attorney. And I want to make sure that you're able to communicate with him or her the same way you are with me right now. Because right now, this is a very productive conversation. Does that make sense, sir?
It makes sense, but as long as my my attorney-client privileges are not violated, I ain't got no problem. I don't have a problem. You can't come to a slot from a bunch of inmates and talk to them. That you just are not supposed to do. That's why they make comments.
Okay.
Go ahead.
Well,
Sorry.
and sometimes I understand, having been a defense attorney for a long time, sometimes there might be some things that are procedural, such as, hey, you've got a court date tomorrow, or hey, this is what, we're going to be in front of the judge tomorrow. Things like that he might not be worried about, that it needs protection. But yes, of course, if there's going to be a conversation that should be privileged, yeah, certainly. It should be done in a privileged way. I understand. And I'm sure that Mr. Hartel, who's heard this today, as he's already said, he will share those concerns with whatever attorney is appointed to replace you. Okay?
Yeah.
All right. So it sounds like I don't need to order him for any further evaluations today, and therefore I'm not going to. The court therefore finds that the defendant is competent to stand trial. The court also grants the oral motion made today on the record for substitution of counsel. And the court will ask that new counsel be appointed for him, either through the public defender office or the overflow conflict office. Mr. Japkus, in case you are unaware, there is what's called the Wexford Misaki Public Defender's Office. They have 4 attorneys. Right, or 5? Yeah, one yet.
Pending the bar.
Pending the bar, all right, they've got 4. And if there is a conflict and one of the other attorneys cannot be appointed, then we have what's called the overflow or conflict office. That is run by another attorney who's a private lawyer. His name is Patrick Cherry. He will appoint or help find another attorney in the area. And that's what we're going to do. The court will have the matter set for a final pretrial conference, and we'll get the case moving. Mr. Japkus, at a final pretrial conference, that is the last day in which the parties can enter a pretrial agreement. I do this because it's not to force the defendant to enter a plea or accept a plea. It is to force the attorneys to exhaust all of their negotiating skills. So when we come to a final pretrial conference, which typically we do on Fridays, those are held 10 days prior to the scheduled trial date. And so I need to know which case is going to trial in 10 days. Just want you to be aware of the importance of a final pretrial conference date, which I will have the case set for promptly. All right. Anything further today, Ms. Carey?
No, thank you.
How about you, Mr. Hartel?
No, thank you.
Any questions, Mr. Japkus?
No.
Thank you very much for your time and your patience today and speaking very level-headed with me and waiting for me to finish. All right, thank you. We're done, sir. That's okay. We're done. We're done. We're done.